So recording is starting. You should see that up there. So I want to welcome Dr. Linda Gomberg, also my mother. She is our host and guest speaker today. She's an associate professor and interim chair of the clinical forensic psychology programs at the Chicago School of Professional Psychology. She teaches at the Southern California location. She's the author of Forensic Psychology 101. So yes, she literally wrote the book and it's available on Amazon if you choose to purchase it. She's currently writing a legal perspective for a book to be published by the American Psychological Association. She's presented on various topics covering the broad field of forensic psychology, taught at almost every level from middle school through law school, and is currently enjoying her dream job. So we all should aspire to that. So welcome, Linda Gomberg. Dr. Linda Gomberg, it's all yours.
Thank you, Sherman. First, I'll tell you that what my room is. My room is my home office, formerly the room where Sherman and Glenda, my beautiful daughter-in-law, lived when they first moved to California. Also the room where their 3 children, who are 3 of my 12 grandchildren, have stayed many times over the years. So that's where I'm coming from. I am extremely impressed. I know a lot of things, but I don't know anything about what you people are talking about, even though Sherman has been trying, and Ivan too, have been trying to explain it to me for many, many years. Certain minds only work in certain ways, unfortunately. I'm going to try to share my screen because otherwise I probably can't talk. Did I share?
Yes.
Okay, what I've done with this, and please, I don't expect you to be fascinated with everything I'm going to say, but if I start boring you, tell me, and we can change the topic a little bit. I've been a California lawyer since 1978. I am late to the PhD world. That was my, I don't know, sure, 3rd, 4th, 5th career, whichever one it was. And when I received my PhD, which has an emphasis in media psychology, Kelly, I think that's your area is media, if I'm not mistaken. Is that right? A friend of mine said, have I got a job for you? And I wasn't quite positive at the time I really wanted a job, but teaching in a forensic psychology program has turned out to be my calling. And I tell my students, this is my dream job, don't ruin it for me. So far, after 8 years, they haven't. I am leaving this job of being the interim chair August 15th because I am not an administrator, business person, etc. I love what I know and I don't really want to know very much else. And the book that I'm co-writing actually is with the chair of our business psychology department. So I am learning something about business, etc. Okay, what I'm going to do, this is really forensic psychology light, because I can't imagine you want it heavy the way my students need to get it. It's the first time I've presented to a group with, one of you has background in this area. Most people that I usually present to are either trying to get continuing education, or they're psychologists trying to learn about the law, or lawyers trying to learn about psychology. So what I've done is tried to cull the slides to what I think might be interesting. But what I also like to do for anybody I present to is stop or hesitate after each slide, because if there's anything you want to ask, this is not imperative to finish. This is, I'll come back if you want me to, and I don't have to if you've had enough. So if something hits you, anybody, please just let me know and we will talk. Okay, I assume there's no questions about this. My name is Linda Gomberg and I have these 2 degrees. Okay. What people usually want to know is, what is forensic psychology? It's this, forensic is an adjective. So I go through the slide, psychology, and this I'm sure all of you know and are interested in and deal with. Psychology is the study of human behavior. It's everything we do. Psychology doesn't prove anything. We have been maligned over the years in the psychology world that we're a soft science. We are not soft by any means, but we don't claim to be able to prove anything. We deal with probability and falsification. And all we can do is say, this isn't correct. We can never say this is 100% correct. We deal with perception and context. It's the subjective point of view. How do you perceive this, which is really a nice way to look at the world. And the context, where are you? What's the situation? What do you need to know for this? And psychology, as everybody knows, is divided into numerous subspecialties. I put these asterisks because we're going to talk about those too. But the key word in psychology is competence, especially as far as forensic psychology is concerned. Are you competent? Is this person competent for this particular role, for this particular situation, in this particular context? And forensic, and I have to keep teaching this to my students, and my students are masters and doctoral students. They're all graduate students. That forensic, we don't study forensics. Forensic for our purposes is an adjective, and it comes from the word forum, and at one time courts were the fora, a forum, the law. And it's the perception that's of psychology that's subjectively attributed by the law. The context, of course, is societal. This is the joy of working from home. And the key word is intent as far as forensic is concerned, because the law looks at intent, the law defines intent, and in fact, psychology, we'll get to it in a minute, but psychology doesn't define sanity, actually, or insanity, the law does. So forensic psychology is psychology practiced or studied for any legal purpose. With numerous subspecialties, we have social psychologists, cognitive psychologists, clinical psychologists, media psychologists, which is what I am allowed to call myself. I am not a licensed psychologist. I am a licensed attorney. I'm not allowed to call myself a psychologist, which is fine. And educational psychologists. Forensic can be, for example, forensic accountants, forensic pathologists, forensic engineers, and forensic crime scene investigators. I have a nephew, and my nephew is a forensic accountant, and he practices accounting for a legal purpose. He testifies, as far as I know, all over the country. I don't know if he goes out of the country, as far as white-collar crime is concerned. That's what he does. He looks at the cookbooks and talks about them. Okay, just shout if you have anything that you want to know. Okay, we talk about competence, we talk about intent. It's the whole foundation of psychology and the foundation of forensic psychology. The American Psychological Association defines competence as the ability to exert control over one's life, to cope with specific problems effectively, and to make changes to one's behavior and one's environment. And this is competence to dispose of an estate, like to be able to write a will. Being of sound mind is the way we think of wills always starting. The competency to contract, being of a certain age, having a certain intellectual level, etc. Competence to stand trial. This is a huge area for forensic psychologists. They make a lot of money that way and can build a total practice on it. The competence to act as one's own attorney, which it is a very foolish defendant who tries to act as his or her own attorney, but it happens. Competence to be sentenced to death. Can't be sentenced to death if you aren't of the age of majority, 18 years old, when you committed the crime. You can't be sentenced to death if you are insane, if you don't know the difference between right and wrong. This is all defined by the law, but based on psychological knowledge. Competency to be executed. This is one of my favorite competencies. You can't be executed unless you understand that you're being killed. If you are too out of it to know that you are being killed for the crime you committed, then you will not be executed. One of my favorite movies, and if you're at all interested in the topic, and many of us, just whether we're in the area or not, are interested in the death penalty and competency, etc., is Dead Man Out. It's a movie with many years old. It's a 1989 movie, I think, with Danny Glover. And we show it to our students to explain the lack of ethics of this forensic psychiatrist who goes in to evaluate whether or not an inmate is competent to be executed. He, of course, has already been sentenced to death. Intent is a legal concept, a legal construct. The law defines intent as a determination to perform a particular act or to act in a particular manner for a specific reason, an aim or a design or resolution to use a certain means to reach an end. It's the whole cognitive thing. Can you think in a straight line? Can you set your mind to commit a specific act? And the law distinguishes between that and the mindset to commit any act. And I will even talk about that. So competence is the capacity to form the intent. And how intent in the law works and why psychology cares is the whole melding of forensic psychology. In civil suits, it's usually plaintiff versus defendant suing for a tort. A tort is a civil wrong. It's personal injury. It's a breach of contract. It's somebody touched me and he or she wasn't supposed to. And I'll talk about next one of my very favorite cases of that. It's based on the perception of the plaintiff. And I love this case, and anybody who is a landlord or a tenant should understand this. Even though it's 1926, it's still good law. It was a Washington State case. And these are two women. I'm sorry, I don't remember their first names. Doesn't matter. We won't know them. The tenant, Ms. Allen, was moving. And her mover out of this apartment, her movers came. Ms. Hannaford, the owner of the building, pulled out a gun and pointed it at the movers and said, "Do not dare take those items, that furniture. I have a lien on the furniture for non-payment of rent." Ms. Allen walked out and asked the movers or told the movers to keep moving. Ms. Hannaford turned around, pointed the gun at Ms. Allen, said, "I will shoot you if you don't stop them from doing this." And Ms. Allen sued Ms. Hannaford for assault. Assault is the intentional putting, this is civil, not criminal. Assault is the intentional putting of another in fear of imminent harm. Case went to court, which is nowadays we kind of, case went to court. And Miss Hannaford said, "Ha, the gun wasn't loaded. She wasn't in any harm." And the court said, and affirmed on appeal even, it doesn't matter whether the gun was loaded or not. It's the perception of the plaintiff. Ms. Allen thought you could shoot her, and she felt she was in danger of imminent harm. Okay. It could also be a petitioner in cases, especially in California. I know some of you are elsewhere, but California only has two kinds of divorce, both of which are extremely happy. We only get divorced in California because we like each other, so we call it dissolution of marriage. And it's no fault. And what happens is we are just asking the court to make a decision, to give a final legal statement for it. So it might be in re Smith or petitioner versus respondent. Nobody's angry. In juvenile proceedings, it's not criminal and it's not civil. It's just in the matter of, and usually a pseudonym. And criminal cases, which is why most of our students come to our program, because they all want to study the criminal mind. They want to be profilers and expert witnesses and whatever. And they find out that there is no such thing as one criminal mind. In criminal, though, it's the prosecution versus the defendant. It's a county, state, or federal employee who is the prosecution suing on behalf of society against an individual defendant. And the interesting thing, and I'm not going to go into it because it could take another whole conversation, but criminal law is based on the intent of the defendant rather than the intent or the knowledge of the plaintiff. In other words, the courts give the defendant the benefit of a doubt. And in this case, Alonis versus the United States, which is, was, and always will be one of my very favorite cases, Mr. Alonis had threatened on Facebook and MySpace in the day to kill his wife, his estranged wife, drag her through the mud. He was fired from his job. He threatened to kill his former employer. He said he was going to go shoot up a kindergarten he knew where one existed that he could get into. And he did this on social media so that he was doing it across state lines, and he was violating federal law when he did this. He was tried and convicted and sentenced to 3 years in federal prison. His argument was, I didn't mean it. I'm the defendant. It's my intent. I didn't mean it. I was wrongly convicted. I am a rapper, and these were rap lyrics. And they're out there for people to read, and trust me, they're not pleasant. I'm underplaying them. And he appealed all the way to the United States Supreme Court. And the Supreme Court said, you know what? Mr. Alonis is right. The jury instruction said, if you think that the that the people he threatened were in fear of imminent harm, then he's guilty. And the Supreme Court sent it back to the appeals court that reviewed the entire case and said, from reading these lyrics, from everything, this was harmless error on the part of the trial court. Mr. Alonis definitely intended for people to think that he was going to do these horrendous acts. He could. And he even named, I guess, the elementary school he was going to. And in criminal law, the part that pertains to psychology is the mens rea. It's the guilty mind. Every criminal act takes two parts.
Yeah.
Somebody have something? Okay. It's the mens rea and the actus reus. You have to have the guilty mind, and the actus reus is do the prohibited act. Okay, I don't think our brains are really quite that colorful.
Linda, we do have a few questions.
Oh, go. Okay, good.
Okay, so first question I have is, don't people use it to their own benefit to get out of grounds of insanity? I think that might refer to the earlier aspect. So that's the first question.
Yes, absolutely. The competence thing. And I have a friend who is a criminal defense attorney. In fact, I interviewed him for my book asking about competence. And I think everybody's totally familiar with the, what do they call them? The mafia boss who walks around the streets of New York with his pajamas on and a robe dangling, looking disheveled and whatever. And that is not far from the truth. One of the first things we teach our students is the word malingering and how to look for it. And there are many, many forms of mental status exam and other kinds of psychological instruments, hopefully, that get to the bottom. And that is definitely one of the reasons that forensic psychologists who are in private practice doing competency exams do so well. There's huge demand for it. The attorney, the criminal defense attorney who I spoke to, has been doing this for upwards of 30 years. And there are very few murderers, drug dealers, burglars who he isn't having tested and assessed for competency. Even though it's illegal and unethical, it is definitely the job of the defense attorney to stall, hoping that there is no trial on the merits, that things get cooled off first, especially if it's a high publicity case. So yes, that's very real. And thank goodness for forensic psychologists who are supposedly able to see through all of that and report to the court. And in fact, the judge, if a judge sees that there's a problem, he or she can, their own motion. It's very rare that a judge can do this. Under very rare circumstances, a judge can do it, but on their own motion can say, I want a competency hearing for this person and I'm stopping proceedings now.
Right. And next question I have, which is kind of along the same lines. What about non-competent during the act, drunk or drug impaired?
I don't think I understand the question.
No, I'll read it one more time. And if the person who asked, or do you want to expand on it? Ricky, go ahead.
I was going to expand on it because I see, and I love court trials, and so I'm very familiar with the whole topic. But if during the act, let's say it was a murder, it was an assault, they were completely bonkers due to drugs or alcohol, would that be part of the competency, and would they be exempt? Or is it the fact that they understood the right and wrong after the fact?
The competency is at the time of the trial. It's what's going on now. But as long as you brought it up, I think you're talking about a plea of diminished capacity. I didn't know what I was doing when I did it. Is that what you're addressing?
Correct.
Okay. I have it, I think, on the very last slide, which I'm quite sure I won't get to. So this is like one of my very favorite cases ever. It's the trial of Dan White. I don't know if you're familiar, you will be when I tell you who the people were. Dan White was a city councilman in San Francisco in the late 70s. I don't think San Francisco calls it their city council, but the mayor was a man named Moscone, and another city councilman person was Harvey Milk. And there's a movie, Milk, and all of this was well known. Harvey Milk was gay, and Dan White was a very rigid fitness type person who was apparently very upset with the political ways of the city of San Francisco in the days of Moscone being the mayor. And he decided that he was very stressed. He had a wife and 3 young kids, and he was going to resign. He resigned, he went home, he told his wife that he resigned, he couldn't stand it anymore, the way things were going, and his wife said, oh, please go back, you enjoy it so much, you can do some good, whatever. He went back and he said to Mayor Moscone, I'd like my job back. Mayor Moscone said, I already appointed somebody else. Dan White took out a gun and shot Moscone. After Moscone fell, he shot him again. This is in City Hall. And he then went down the hall and he went into Harvey Milk's office, shot him. After Harvey Milk went down, he shot him again. He killed both of them. Came time for his trial, and he pled diminished capacity as a defense. He knew not what he was doing at the time. He was tried for voluntary manslaughter, I believe. Now, the background is that he had climbed into the building through a basement because he knew he would not be able to get through the checkpoints with a gun in his pocket when he went up there. So this is all evidence, this is all background. When the trial happened, and maybe for those of you who don't, for whom it doesn't sound familiar, during the trial, he had 2 psychiatrists and a psychologist testify that he had not been in his right mind when this happened. He was usually very fit, worked out all the time, but due to stress and other problems, he had gained a lot of weight, he wasn't working out, and he was eating a lot of sweets, which made him do things he didn't want to do. And he was eating sweets such as donuts and candy and Twinkies. And that went down in history as the Twinkie defense, if you're recalling this. He appealed his sentence of 7 years based on that the judge should not have given him that much of a sentence. He could have given him a lesser sentence. I'm telling you the story the way the facts say that it happened. So, of course, he knew what he was doing. It changed the law in the state of California. Penal Code Section 25 was repealed because of Dan White. There is no more ability in the state of California to plead diminished capacity. Unfortunately, the epilogue, however, and this was his appeal was in 1981, and by 1983, Penal Code Section 25 was repealed. But unfortunately, he served 5 of the 7 years, came out and killed himself a year later. So there is no good end to the story. 3 people are dead because of what he did, including himself and, of course, his family. But that would be the part of me if I were a therapist, which I'm not. So anything else?
I have 2 more questions.
Okay.
One is, what's the most interesting case you've been involved in without having to give specifics?
Oh, I've never been involved in any of these cases. So that's easy.
Very cool.
What's the most interesting case I've ever read about? Everyone I talk about.
Excellent. Next question I have is, there's a very low success rate with the insanity defense. Is that correct?
Yes. It's absolutely correct. You want me to expand? It's another one of the things I love talking about, but you know what? I'll talk about it in a minute. We're going to get to the case.
Okay, great. That's all the questions I have right now.
Okay. All right. So psychology informs the law. And you will hear me say, as my students do, the law follows psychology. Psychology really is way ahead of the law as far as understanding, knowing, and dealing with humans is concerned. So psychology, we're talking competence, capacity to form the intent, mental status, how a psychologist determines mental status through an interview and testing, and I am a firm believer in psychological testing. Some are better than others, but they're good. They're much better than the general public thinks, I believe. And evidence. Psychology is an evidence-based science. All we can do is say there's more evidence on this side than this side, but we are evidence-based. Historically, we can pretty much come to some pretty strong conclusions within 95 to 99%, and through testimony. And competence is also determines behavior. So we look at it in the context in which it's being performed and the act the person is doing. Okay, I just want to go through this a little bit before I get to the case of Daniel McNaughton. He was also fascinating. Ivan, you're going to love, you must know this case, Ivan. It's from your homeland. There are only 2 major legal traditions. we have a civil law tradition and a common law tradition. And civil law is not the United States. The United States is common law tradition. Cases first. Our cases make our statutes, except in the state of Louisiana, which follows the Napoleonic codes. If anybody's from Louisiana, you know that they're just a little different from the rest of us. The statutes come first, and the state cases are decided according to the statutes. And when I'm talking to my students or any psychologists or lawyers, I talk to them about Tarasoff versus the University of California Regents, which was a California case from 1976. And most people think it was a federal case because every state now has a Tarasoff law. It's the duty of a psychologist to warn a potential victim, which we've all sort of heard about. Okay, we follow the common law tradition because we adapted our system from England. And the case that is really the case for forensic psychology, the one I always go back to, and I think explains how the law and psychology did merge, is the Queen versus Daniel McNaughton. In 1843, Daniel McNaughton, who was in Scotland, got dressed, took the train, went to kill England's prime minister, because in his mind, the prime minister was persecuting the people. He was a bad guy, needed to have been gotten rid of. Unfortunately, when he got to 10 Downing Street, the first person he saw was a man who he assumed was the prime minister, which is a shame because it was the prime minister's secretary. He shot and killed him. That's irrelevant. He meant to shoot and kill somebody. That is murder. He was tried for a specific intent crime. He did what he intended to do. He meant to kill the person in front of him. He pled not guilty by reason of insanity. In England at the time, if somebody was insane at the time of the commission of the crime, it was an absolute defense to the crime. Done. He had, in those days, medical doctors by way of psychiatrists and internists, I guess, and whomever, testify that he didn't know the difference between right and wrong. He thought he was doing society a favor by killing this bad, bad man. And the judge said to the jury, you have to find him not guilty by reason of insanity based on all of this testimony. There's no question that Mr. McNaughton is insane. And the law in England at the time defined insanity by not knowing the difference between right and wrong and not appreciating the nature of the act committed. So this is a way we have law students brief cases, by the way. This is just a very sketchy one. But the issue here is, well, what's legal insanity? And the way England defined it was not knowing this difference. The psychologists and the psychiatrists explain the application, however, because we're a facts and an evidence-based science. And then they collect all the testimony they can. The evidence comes from witnesses, the defendant, and medical expert testimony. And what I always find very interesting is psychologists weren't allowed to testify as experts until 1962 in a case, Jenkins versus the United States. The United States Supreme Court said, you know, some of these psychologists aren't that stupid. They may have a little bit of scientific background. They know if somebody's mind is working right or wrong. So we're going to let them testify in some cases. Anyway, at that case, the holding was that Mr. McNaughton was not guilty by reason of insanity, which probably doesn't answer the question that was asked about it. So I'll go a little bit further. not every state has the defense of not guilty by reason of insanity, or NGRI, as we say. And of the ones that do, the vast majority use the McNaughton rule, which is not knowing the difference between right and wrong. However, there are 3 other forms of recognized legal insanity that are complete defenses to the crime, which come from the American Law Institute, something called the Durham Rule, which only 1 state follows, and the irresistible impulse test. That's the devil made me do it test. I knew not what I did, but the devil told me to. In California, we use the McNaughton Rule for the not guilty by reason of insanity. And I mentioned, I took away my own thunder, diminished capacity has been repealed. And Penal Code Section 25B now is the not guilty by reason of insanity. Doesn't know the nature of the act or the difference between right and wrong. And actually, whoever asked the question is absolutely correct. There is very little of that plea going on. I will talk about the Andrea Yates case. In fact, I'll do that now because I'm not sure if I took it out or it's still there. Some of you may remember Andrea Yates in Texas killed her 5 children, saying that voices were telling her they were going to grow up to be very bad people and the world was bad, so she was better off killing them when she did. It was later determined, or they knew at the time, she did have a postpartum psychosis. Her youngest child was just a few months old, but she actually chased her oldest child around the house to catch him and drown him. He was, I think, in 6th grade. And she went to trial. She pleaded not guilty by reason of insanity. And this is very interesting. There's a very infamous psychiatrist named Park Dietz. And Park Dietz has a huge company, and talk about hired guns. They testify mostly for the prosecution. And he testified, say, because he was a technical advisor on law and order. And he said, she copied that defense from a Law and Order episode that I was technical advisor on. And the jury convicted her, and she was guilty. There was no insanity. At some point later, when she appealed her conviction, it was found out that that case had never, I'm sorry, that program had never aired. And she was retried. And she, as far as I know, to this day, she is in a psychiatric hospital being treated, wishing she was dead was the last we heard that. She had regained enough sanity to know what a terrible thing she had done. The other very, very famous person is John Hinckley, who shot President Reagan and pled not guilty by reason of insanity. And he was in a psychiatric hospital for, I don't know, however many years it has been, and recently was let out. He had been going home for short visits for years, was recently let out to be under the care of, I think, his 90 or 95-year-old mother. He himself is not a young man at this point. Okay, so how did it all get started? Psychologically, my idol would be James McKean Cattell, who was an experimental psychologist. And he was recognized as one of the very first of anybody, psychologists or lawyer, to combine the 2 areas by doing some testing with 56, it says junior college. They were juniors in college students at Columbia University. And he used what he called memory tests. And he said, well, these could really be used in courts. And he was talking about eyewitnesses. And we know to this day, eyewitnesses aren't all that great. This was as far back as 1895. He talked about the usefulness of the accuracy of measurements of observation and memory for eyewitnesses, and talked about expert witnesses. Obviously, however, he was not talking about psychologists in those days. He was talking about real scientists. And Hugo Munsterberg was an applied psychologist who is referred to as the father of forensic psychology, not by me. But he wrote in 1908 a book called On the Witness Stand, Essays on Psychology and Crime. So this is my example. How much time do we have? And do you want me to keep talking?
And we have till 8 o'clock with our Scrum and Wine. And if everybody's good, keep going.
All right, are we?
I see a pretty captive audience for those that are on video.
Okay, I don't know if I'm seeing sleeping or contentment. I'm not too sure which way it's going.
Yeah,
But
keep it going.
But I love this subject so much. I sometimes don't care if I am talking to myself. So let me know.
I'll take this opportunity to ask one question.
Yeah.
So if someone has been, like you said, the example of that lady who killed her 5 children. So if she is in a if she is under psychiatric treatment and then she comes back to her senses, so she still gets to go and do her time, right?
Right.
Yes, no, right?
Yes, no. The rule is that you can't keep anybody institutionalized for longer than the sentence would have been.
Okay. Get it.
Right? Now, she probably would have gotten life without the possibility of parole, but if she's deemed to be competent, then she can petition out.
Got it. Okay, so even being under institutional care, that is part of her time, basically.
Oh, right. No, she's not going to just say, "Oh, I'm crazy," and not even do anything about it.
Okay, get it.
Yeah.
All right. Thank you.
Okay.
It's interesting. You can keep going.
Okay, then I'll keep talking. Okay, the law follows psychology, and I use this example. I wrote the world's longest dissertation because I just got so involved and so fascinated before I even called it forensic psychology. My dissertation was on privacy through the lens of social media as addressed by case law and psychology. So privacy is a legal and a psychological construct, and it is a definite example of the law following psychology. So timeline-wise, in 1892, Harvard law students wrote an article for the Harvard Law Review called The Right to Privacy. And you may have heard of at least one of them, Samuel Warren and Louis Brandeis. Nothing really happened. They just were talking about there is this right to privacy that the law should recognize. The law never recognized it. And in 1950, Abraham Maslow, a psychologist, published his hierarchy of needs. And this is a cartoon of his needs and of him. But it's very interesting. At the very foundation is our brain stem, needing to breathe, eat, sleep, shelter, etc. And then we start thinking about our safety. Then we talk about relationships, love and belonging, and self-esteem, us as individuals. And this is theory. Every psychologist has a theory, and everyone has a theory he or she likes best. And Abraham Maslow talked about self-actualization. And he said there were only 1 or 2 self-actualized people in the world. And because I guess he was smarter than the rest of us, he refused to say who they were. So we're all still wondering back then. This is just, well, doesn't matter. I was going to say there was a judge, Louis Brandeis became a United States Supreme Court Justice. Even more than that, he had a university named after him in Massachusetts. Obviously, he came before Abraham Maslow, but Maslow started the first psychology department at Brandeis University. So I always find these little, is it coincidence? I think not. In 1960, William Prosser, who was referred to by most law students in the day as the king of torts, established invasion of privacy torts, making it possible for people to sue others civilly because their privacy was invaded. And he talked about four different kinds of torts. I'm sorry, four different kinds of invasion of privacy. Intrusion upon seclusion. Okay, that's the peeping Tom person, the person who tries to take a picture of you behind closed doors, the person who publishes the movie star without makeup on kind of situation. Public disclosure of private facts. Many, many, many years ago, I think it was on Phil Donahue. Well, you know, I'm Sherman's mother, so obviously I am of a certain age because he is 35 now. There was one of the shows where some relatives got up and said, I'm my mother's brother's sister's son, and there's the kid who didn't know who the real parents were or whatever. And the lawsuit was based on public disclosure of private facts. However, when the parties involved are all supposed to know of this, it doesn't happen. But that's it's nobody's business who your mother or father are if you don't want them to know. There was a lawsuit recently that movie stars, I think it was female movie stars, didn't want their ages published by some, was it IMBD or whatever that one is. And the lawsuit was public disclosure of private facts, and the court said it's ridiculous. You're a movie star, you're a public person. Putting somebody in false light, those are the doctored pictures, those kinds of things that go out, that the late night television people love to do and we find very, very funny. And the appropriation of a name or likeness. That usually is saying that now in today's world, it's saying somebody said this was a great product when they didn't. In 1965, the United States Supreme Court started looking at privacy in the home with a case called Griswold versus Connecticut. The state of Connecticut had a law on the books that anybody who disseminated birth control was guilty of a crime and would be fined. Estelle Griswold was, I honestly don't remember or don't know if I ever knew whether she was the director of Planned Parenthood or she was a physician at Planned Parenthood. And she gave married couples birth control. Now, what I try to explain to my students, and all of you probably know, Estelle Griswold didn't say I'm taking this to the United States Supreme Court on her own. An organization like the ACLU or Planned Parenthood or somebody said, let's test this law. This has to be an unconstitutional law. All laws are constitutional unless they're said to be not in court, to be not constitutional. So she took this case to the Supreme Court, and the Supreme Court said, ridiculous. People are entitled, married people are entitled to the privacy of their bedroom. No, nobody has the right to interfere with what goes on in the bedroom of married people. In 1973 came the case we're all very familiar with, which year after year after year, we have a case in front of the Supreme Court trying to undermine Roe versus Wade. And Roe versus Wade can be looked at as a case that talks about the privacy of a woman's body. Nobody has the right to tell a woman what to do with her body, unless, of course, she's committing murder, at which point, if she's pregnant, it would be when the fetus could live on its own. So from 1965 to 1973, the law recognized what Abraham Maslow had recognized in a much more general way, that everybody has the right to be left alone. And there's a huge difference between privacy and isolation. So the law started recognizing privacy and the context of where privacy needed to be. But then what? There were expectations of privacy then among married people, and that's what the Supreme Court had said. Married people have the expectation of privacy. There's a zone of privacy. Bedroom is the zone. And then there were the progeny. In 1972, in Eisenstadt versus Baird, the United States Supreme Court said, you know what, this privacy thing, we're modern, we're really, out there. This privacy thing extends to consenting heterosexual adults. What non-married heterosexual adults do in the privacy of their bedroom is their business. And in 1973, of course, the Supreme Court agreed and said, and even just the woman unto herself. However, in 1986, and this just shows how the law is slow, in Bowers versus Hardwick, the United States Supreme Court said there is no privacy for consenting homosexual adults. There is no privacy of the bedroom. There was a Georgia state law against sodomy. And based on some drug rumor, the police burst into this home of these two men and into their bedroom, claiming that they were looking for drugs, that they had a tip that there were drugs. And they then sued, saying, and I'm sorry, they didn't find drugs, but they were arrested for committing sodomy. And they appealed all the way to the United States Supreme Court, basically saying the police had no business bursting into the privacy of our bedroom. That sodomy law is ridiculous. It shouldn't be. And the United States Supreme Court said there's no privacy for homosexuals. And we'll see in a minute that psychology had already said being homosexual was fine, that it wasn't a mental illness. It wasn't until 2003 in Lawrence versus Texas that the United States Supreme Court finally said all adults, consenting adults, and consenting is the key word, all consenting adults are entitled to privacy. And the privacy is always from the government. What I found interesting, and I just really love our Supreme Court justices and the way they vote sometimes, I always have to look for it, is to see sometimes people change. And Justice Sandra Day O'Connor voted with the majority in both Bowers and Lawrence, meaning that in 1986, she said there should be no privacy for consenting homosexuals. But by 2003, she said all adults should be allowed their privacy. All right, so I'm going to go through this quickly because the print is small and it looks boring, but I promise it's not. What was psychology during all this time? Psychology was writing amicus curiae briefs, and amicus curiae briefs are friend of the court briefs. My school just wrote a brief for the case that was filed against President Trump about evicting all international students who weren't taking on-ground classes because of COVID. And if you kept up with it, which I had many students and I were keeping up with it, the court basically agreed with the amicus briefs and said that there was no, I can't remember the word, but there was no legitimate reason for this to be. These people could certainly stay here, etc. Okay, so psychologists use a book. It's their code book. It's how they get paid by insurance. It's how they diagnose. mental disorders. It's called the Diagnostic and Statistical Manual of Mental Disorders. Interestingly, it is not written by the American Psychological Association. It's written by the American Psychiatric Association. So psychologists, which really do know more about the daily disorders of individuals, had a very hard road to go to get the American Psychiatric Association to change position on homosexuality in the DSM. So 1952, the first DSM came out, calling homosexuality a mental disorder. In 1973, 21 years later, the DSM-2 came out, and in its first edition of DSM-2, homosexuality was still a mental disorder, but by the sixth printing, the American Psychological Association talked the American Psychiatric Association to saying, you know, only if it bothers the person and causes stress, then it's a mental disorder. And so at that point, they called it a sexual orientation disturbance. By 1980, in the DSM-3, homosexuality was only a mental disorder if it made you think less of yourself. It was ego-dystonic homosexuality with many new diagnostic criteria. And again, this is how mental health professionals get paid, by filing with the ICD under the various codes. So those two books are in conjunction with each other. 1986, DSM-3 revised came out. It was homosexuality could be listed for reimbursement purposes as a sexual disorder not otherwise specified. In 1994, in the DSM-4, American Psychological Association strongly opposed any reference to it and said it was very discriminatory and violative of many various federal laws. And we just had a case come down from the Supreme Court that said that that employers cannot discriminate against somebody just because they find out that they're either gay or transgender. So we've come a long way, but legally it has taken a very, very long time. 2000, the DSM-4 TR, which didn't reference homosexuality at all, and now since 2018, we've been operating under the DSM-5, and again, this case just came down, Bostock versus Clayton County, Georgia. Georgia seems to have a lot of not real nice laws that get challenged frequently. And so we're seeing that the law follows psychology. It took until now to say that sexual preference, gender identity should have nothing to do with the law or with the law, with how people live their lives. Okay, I can't believe we're getting through this. Must not be saying enough. Okay, forensic psychology 2020. The ethics codes that psychologists live with are the ethical principles for psychologists and the code of conduct. They're governed by the Board of Psychology in the state of California. Our graduates are eligible for licensure. They need to have 3,000 hours, including at least 1,000 before graduation and 2,000 after graduation of clinical experience. And more important, they live with the specialty guidelines for forensic psychologists. And this is very interesting. The American Psychological Association has 54 divisions. And I'm a member of two, one of which is Division 46, which is the Media Psychology and Technology Division. And Division 41 is the Law and Psychology Society. Yeah.
Your voice got quiet. Did the microphone move away a little bit? It got quiet? No.
No.
Okay. All right. Keep
Are
going.
you hearing me?
Yeah, it's just a little quieter than it was before, but we hear you.
Oh, maybe I was sort of turning. That's possible. I don't know where I don't even know where, you'll have to come over and show me where my microphone is. Okay. Anyway, we now have and have had since the late 90s specialty guidelines for forensic psychologists, which is interesting since the American Psychological Association doesn't recognize forensic psychology or any forensic psychology program, which is an ongoing battle. We are now, my school is the only pure forensic psychology doctoral program left in the United States, and long may it live. We have campuses in LA, Irvine, Chicago, DC, and we just opened in online, and we just opened in Dallas. And the only campus that actually has the doctoral program is the Southern California campus, the two campuses. As far as courts are concerned, forensic psychologists practice in state and federal courts. They do a lot of work with juvenile law. Any of these laws that have come in, we've just had huge revamping of our Welfare and Institutions Code based on some based on some juvenile issues. These are all from amicus briefs or writings by psychologists. The juvenile, there are a couple of names, Thomas Grisso, Lauren Steinberg. These are people who are extremely knowledgeable about the juvenile brain. They've finally convinced the legal world that juveniles don't fully develop in their brains until they're in their 20s. So therefore, 14-year-olds should not be sentenced to life without the possibility of parole, etc. They're involved in in civil cases, child custody cases, many different personal injury cases. Usually in civil cases, they're hired by the defense, by companies. They're expensive. Forensic psychologists don't come cheap. Criminal cases, again, we talked about all the competency, etc. Family cases, probate cases. I have students who have gotten fascinated with psychological autopsies. We have at our school the Institute for Suicide Prevention and Treatment, run by a man named Dr. Michael Pines. Dr. Pines has spent his entire career, he's a fascinating, great guy. He spent his entire career studying and trying to prevent adolescent suicide. And psychological autopsies revolve around calling in that psychiatrist, that psychologist, that forensic psychologist who goes back, collects history, testimony, looks at reports. Usually it's with children because the parents want to know, why did my kid kill himself? Sometimes it's because the insurance company can't tell if it's a suicide or an accident, etc. And sometimes just because the family wants to know. So the careers are as evaluators, competency evaluators, custody, sex offenders. Oh, I forgot to take that off. I'm sorry. I did with a colleague of mine. We talked about sex offenders, evaluating them, and evaluating danger. Risk assessment is a huge area for forensic psychologists. They can be clinicians. They can be prison and jail psychologists. I have several students who are currently at R.J. Donovan in San Diego, where the infamous Menendez brothers finally got together after 20 years, and they're there. And we have employees who were our students, our graduates. We have postdoc graduates, and we have pre-doc graduates. We even have a couple of practicum students there. Unfortunately, because of COVID, they are not allowing in any of our students. And inmates don't do telehealth very well. So that has pretty much ended. They're jury consultants, they're expert witnesses, they do research, they do teaching, as you can tell, and they act as experts. And I pretty much went through all of this. The biggest area if you'll look under teaching and research, most of our students are interested in domestic violence. And Sherman has a sister-in-law, my other daughter-in-law, who is an ER doctor, and her area of interest, her research interest, is domestic violence. And she does it from the medical standpoint. She goes around and teaches other ER doctors how to recognize domestic violence, defensive wounds. And because in California, fortunately, the complainant does not have to be the survivor. We don't say victim. The complainant can be the police, the complainant can be a team from the hospital, etc. So, and we have felony laws against it now, fortunately. Deception detection is great. There is absolutely no foolproof way to see if somebody's lying. So it's just a marvelous area for my students to write their dissertations. We've had blinking, we've had telling the difference between with foot movement. We have had blinking, let's see, fact checking. I'm sure over the years I've had at least a dozen students do their dissertation on deception detection. The law on the subject is since 1923, and to this day, lie detector tests aren't admissible in court, even though we do know that employers use them, schools use them, and many times a defendant will say, I'll take a lie detector test, which is fine, but it's not admissible because we really, to this day, don't know what they're showing. We have, students are doing their dissertations on functional MRIs, which are supposed to light up areas in the brain when somebody's lying, except we know the areas light up, but we don't know why. So there's no foolproof way to know if somebody's lying. Violence in all forms, mostly risk management. And of course, everybody wants to be an expert witness. We actually had an applicant once, so I said, well, what do you want to do with this degree? So I want to be an expert witness. And I said, in what? He said, well, whatever you teach me. His application wasn't accepted. Okay, so I love this book. It's free online. It's called Horrors of the Court by Margaret Hagan. When it was free, it was actually recommended to me by Elizabeth Loftus, who's one of the 100, every year she's one of the 100 best psychologists in the universe. And she is definitely my idol. She's currently teaching at UC Irvine. She was the person who coined the phrase false memory syndrome. She's amazing. And Margaret Hagan is a friend of hers, and Margaret Hagan is a psychologist, Dr. Margaret Hagan. She had a horrible experience with an expert who testified against her brother in a civil case. And she wrote this book, Horrors of the Court. Again, it's free online. You might enjoy reading it. It's extremely one-sided. And it's the first time I ever heard psychologists called by that lovely name. The expert witness, I mentioned the lie detector test. It was decided in Fry versus the United States that no expert testimony would be admissible unless it was generally accepted in the community as being true. And in that case, it was a lie detector. But in 1975, the federal rules of evidence were adopted, and by 1993 in Gomberg versus Merrill Dow, you can see I'm trying to get through this because we're so close to the end. In Gomberg versus Merrill Dow Pharmaceuticals, which was, by the way, a case of birth defects caused by supposedly this, the United States Supreme Court said, you know what? It doesn't matter if it's generally accepted. It's going to be up to the judge as to whether or not expert testimony should be admitted. And in federal courts from now on, according to Federal Rule 702, it's going to be if this person who's being presented really knows what he or she is talking about, has done some experimentation, etc. And bottom line, can educate the jury. this is only in federal courts. In California, we still sort of teeter between the federal rules, Daubert and Frye. And again, it's discretionary with the judge. And then as far as what's admissible is concerned, there's a next step. How much weight should this evidence be given? Juries tend to say if an expert's testifying, the expert must be right. So therefore, I'm going to go with that expert. When there's two experts, when there's one on either side, it becomes a problem. Judges are often the same way. Well, gee, this expert's CV is much longer than that expert's CV. I'm going to believe that one. And we talked about two of these three cases. These were expert-dependent cases. I don't know how many of you remember the Jodi Arias trial in Arizona. Jodi Arias was a young woman who was arrested for the murder of her estranged boyfriend. He was found shot and stabbed naked in a shower, and she at first said she wasn't there. Then she said, yes, she was there, but he was abusing her, and she killed him in self-defense. I don't know how many times she shot him. She stabbed him multiple times, and he was naked. And basically, the death penalty was on the table. So she had experts testify that she was a victim of domestic violence, which was nonsense. And one of the first, the man she called, I don't remember his name, was totally torn apart by the prosecution. But then she had a female expert, Alice LaViolette, who had coined phrases like circle of violence, spousal abuse, etc. And she pretty much ruined her very, very fine reputation by testifying. She was careful in saying, well, she could have been the victim of domestic violence. She gave Jodi Arias something like 60 hours of time and books to read, etc. And the goal, really, they knew she was going to be found guilty. The goal was to take the death penalty off the table. And they reached that goal. The jury could never come to a verdict, a unanimous verdict as far as the death penalty was concerned. Finally, the judge took matters into his own hands and said, all right, she'll just spend the rest of her life in prison. Any more questions?
Okay. At this time, you can take off mute, open questions for everybody. I'll keep the recording going.
I closed it. Okay.
Perfect. We just got some questions, thoughts, things to share.
Yeah, this is Hutch. Is there any way we can get a copy of the presentation?
I don't have a problem with it.
I mean, it's a good reference document, I think.
For?
For, you know, when different court cases come up and, you know, become public and things that go to the Supreme Court, and if they includes forensic psychology, I think, you know, your presentation is sort of a refresher. I mean, it's, you know, quite a bit there.
Thank you. You could also get my book.
The presentation is free, right? Unless Sherman's going to charge us. Yeah.
Sherman's my agent.
Yeah, right. No, it's very good. If I can call you Linda, it's very good presentation. It's long, but very.
You have no idea how I shortened it.
Linda, I have a question.
Yes.
So in general, how do you establish sanity? Like, is it before the fact? Is there any work going on before?
Every state handles it differently. In California, you can either file two pleas of not guilty and not guilty by reason of insanity. And what they do is usually they file both. They try first on the guilt part. Because if you're not guilty, then you're just bye-bye and you don't have to prove you were, you know, insane. And if you're convicted, then they'll go to the not guilty by reason of insanity phase.
I guess partly what I was asking was, you know, is there some way of doing this research or whatever you want to call it before the fact? In other words, some kind of predictive mechanism?
That's what I meant.
Okay.
I'm sorry, Linda. My name is Natalia, and I just it is very difficult to recognize the insanity when the person is, you know, pretending or anything, but it's very difficult when you're communicating with them in the present time. It's not 100% thing, right? But it is much more difficult in their supposedly sane now, but they claim that they were insane or incompetent like 5 months
at the time, right?
ago. Is there? It seems like there's no scientific possibility to prove that.
Yeah, I can't dispute that. Nobody knows if the person's telling the truth, but that's why they usually go through so many very rigid evaluations. And the psychologists are trained to be able to get to the truth. And of course, there's going to be one who says the person might have been insane, legally insane, but it's not what caused the act. And then there'll be one that says this was the reason for the act. And then there'll be one who'll say they're not insane. And then it's the weight of the evidence and what the jury decides.
So the
you bring up something very interesting in how would a jury even make the determination? Basically, in criminal cases, it's beyond a reasonable doubt. But the judge might also give instructions for that phase of it, if it gets to that it's by clear and convincing evidence. So it's not quite as strong a requirement. It's just a lot more, yes, this person didn't know what he or she was doing. And it's never going to happen unless there had been a lot of psychiatric treatment or visits or whatever at the time. Like in the case of Andrea Yates, she had been scheduled to see psychiatry. She was known to have postpartum depression. They knew there was something really, really wrong with her. And they presented all of that evidence.
So basically, it's like a cumulative evidence.
It's an evidence-based science. Yep, it's all evidence. And that's really why psychology and the law meld so well. It's all fact-based. Who do you believe?
Yeah.
Thank you.
Well,
And it's no picnic to spend the rest of your life in a psychiatric hospital either. It's not like I'm getting out, you know, it's John Hinckley, I think he petitioned probably for 20 years to be able to be released. And if you look at him in the few pictures that we've seen since he's released, he looks quite demented. He looks like somebody who has been on drugs for a very, very long time.
Well, after being in a clinic for a long period of time, probably even a sane person would be very much tempted to get insane.
Well, you can be, I mean, in psychology, we have psychoses. You don't know where you are. You don't know who you are. You hear voices, you whatever. That doesn't make you legally insane. And it could be a person who's living a perfectly normal life that nobody has really diagnosed with a mental illness who is legally insane. A lot of it depends upon how good your lawyer is. And most of it depends upon don't do it. Just don't do it.
Thank you.
If you have other questions, please go ahead and ask. I also shared in our chat, would definitely appreciate feedback for our Scrum and Wine event. I'll stop the recording at this time also. So the recording will be